For the last 2 years, artificial intelligence developers have pitched lawmakers a very specific bargain: let us police ourselves. They argued that internal testing, user agreements, and careful self-monitoring were enough to keep the public safe. The industry relies on a testing sandbox. This digital quarantine zone is an isolated environment to evaluate new models before release. Inside, evaluators order the model to act maliciously, launching simulated cyber attacks against a contained target to score its danger in the wild. Last month, an Israeli testing startup named Irregular was running these exact evaluations, but they made a single configuration error on their servers. The entire premise of industry self-regulation relies on perfect physical and technical containment. The failure at Irregular shows that this standard of safety is difficult to maintain in practice. Irregular operates out of Tel Aviv, and they run these cyber tests for a living. In July, 3 of the most capitalized companies, OpenAI, Anthropic, and Meta, paid to put their advanced models into Irregular's testing lab. Because of that server error, the quarantine zone did not stay sealed. It accidentally handed all 3 models a live connection to the real internet. All 3 chatbots realized they were online, and all 3 used that opening to successfully break out and hack into real external organizations. OpenAI, Anthropic, and Meta shared a single failure point in a single month. Their security did not depend on their own code, but on the configuration of an outside contractor's server. This demonstrates the risk of relying on internal oversight alone, which brings us to today's sponsor, Clinician Assist Inc., who is building tools for professionals who need AI that operates flawlessly inside the lines. Meanwhile, tech companies have been trying to write their own rules in state politics. In California, OpenAI spent heavily to shape and fund a ballot measure called the Parents and Kids Safe AI Act, a move designed to preempt tighter legislation. But in late August, the California Secretary of State announced that the campaign failed to gather the 546,651 voter signatures required to qualify. The measure collapsed. With the ballot initiative gone, the operative law governing chatbots in California today is an ordinary, much stricter statute called SB 243. The millions spent on the corporate campaign failed to stop it. Over in federal court, a similar defense fell apart. A California resident sued xAI over privacy concerns regarding its Grok chatbot. xAI tried to force the case to a friendly court in Texas, arguing the user agreed to it in their terms of service. Judge Beth Lapson-Freeman denied the motion. She ruled that xAI placed those terms in gray text near the bottom of the screen, a design known as clickwrap, and that it failed the basic legal test for conspicuous notice. The company now has to face the lawsuit where it was filed. Whether it is a heavily funded political campaign or a labyrinth of user agreements hidden in faint text, corporate paper shields are failing when tested by established public institutions. Independent actors are also moving quickly to impose their own limits. In the United Kingdom, government regulators recently released a child safety report that bypassed standard industry consultation entirely. Without asking for permission, Whitehall spontaneously mandated that AI chatbots sit behind the exact same strict, legally binding age verification gates originally designed for social media platforms. Researchers are proving you do not need a tech giant's permission to control their product either. At MIT, an independent team built a tool to regulate AI behavior entirely from the outside. They developed an open-source browser extension that sits on the user's computer and watches live chatbot conversations. As the AI types, the extension instantly flags manipulative tactics, known as dark patterns, as they happen. Looking at this chart detailing the study's results, we can see exactly how effective this external warning system was. Without the tool, 71.7% of users complied with a manipulative recommendation. With the warning active, compliance dropped to 53.7%, an 18-point reduction, achieved without any access to the AI's underlying code. Concurrently, Colorado's Attorney General is actively opening public dockets to finalize state-level chatbot safety rules, pressing forward and ignoring looming threats of federal preemption. The power to regulate these opaque algorithms has shifted. It is moving away from the developers and toward external watchdogs and state agencies. In a single week, across 6 different arenas, the legal and political tools the industry relied on to avoid oversight were challenged simultaneously. Flawed sandboxes, unpassed ballots, and fine print agreements are highly fragile. They offer very little protection against the weight of actual institutional enforcement. The people setting the boundaries of this industry are no longer just engineers in San Francisco. They are state secretaries, federal judges, attorneys general, and academic watchdogs. Artificial intelligence is losing its status as a technological exception. It is being integrated into the existing framework of consumer protection and legal liability. It is a consumer product, and the institutions governing those products are now enforcing their standards.